Judgment in the appeal, Public Prosecution Service of Northern Ireland against McKee and Elliott.
Lord Hughes will give the judgment.
Although fingerprints can still be taken by traditional methods of ink pad and paper, it has been possible for some years for them also to be taken by electronic devices, which involve essentially a scanner and a computer. There are several advantages in this method, especially for sending the prints to somebody else, for storing them, and for searching the database. In the fairly early days of electronic fingerprint taking, it was thought for a while to be a good idea to define in legislation the kind of device which could be used. Legislation was enacted in both England and Wales and in Northern Ireland to provide for the Secretary of State to approve the device to be used. Quite soon after that, the decision was made not to continue with that requirement. That was perhaps in part because the components of the devices were constantly being improved or updated. The type approval legislation in England and Wales was never brought into force at all. But the equivalent Northern Irish legislation was brought into force, and by oversight, it wasn't promptly repealed when the decision not to continue the need for type approval was taken. The error was spotted only some time later, and as a result, the type approval legislation was in force between March 2007 and March 2009 without there being any formal approval by the Secretary of State for the device. The two appellants were some of many people whose fingerprints were taken by the police while they were under investigation and using the electronic device. They were convicted of stealing building materials from a depot, and an important part of the evidence against them was that a fingerprint found on the stolen goods matched the print of one of them, Elliott. The issue in the appeal was whether the statute meant that if type approval hadn't been given, any fingerprints taken by using the device became inadmissible in court. Answering that issue involves asking what consequences Parliament must have intended to follow from the absence of type approval. Was it that the use of the device was not permitted so that it could be prevented, and so that a suspect could insist on the ink pad and paper method? Or was it also that fingerprints which were taken and recorded couldn't be used in evidence in court? Our conclusion is that the added consequence of inadmissibility was not intended and does not follow. Where it is intended, statutes often say so expressly, and this one did not. Moreover, the fingerprints which were taken on this device were not the disputed prints on the stolen goods or at the crime scene. They were control sample prints which could be provided again at any time, whether by ink pad and paper or any other means. That meant that their accuracy could easily be checked at any time. It therefore was not the same as, for example, a breath test which measures blood alcohol, or a reading from a speed gun which measures the speed of driving, both of which measure something at a moment in time which cannot be repeated or checked. The control fingerprints taken from Elliott in this case were not suggested to be in any way unreliable, and it wasn't suggested that the print found on the stolen goods did not match his at more than 40 points. There was, we concluded, no reason to prevent reliable evidence from being admitted, whether it was relied upon as here by the prosecution, or as might happen in another case, if it were relied upon by a defendant to prove that the crime scene fingerprint was somebody else's. For those reasons, which are more fully set out in the judgment, the appeals were dismissed and the convictions stand.
Now adjourned.